Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? A landmark piece of legislation, the Pregnant Workers Fairness Act provides expansive protections for workers impacted by pregnancy, childbirth, and related medical conditions. The EEOC's final regulations provide important clarifications and insights into how the agency plans to enforce the law. On this episode of We Get Work, we discuss how the PWFA compares to existing state or local laws and what steps businesses need to take to ensure compliance. Our hosts today are Brett Anders, a principal in the Berkeley Heights office of Jackson Lewis and co-leader of the Life Sciences Group, and Jennifer Bologna, a principal in the White Plains office and member of the Disability Leave and Health Management Group. Brett and Jennifer, the question on everyone's mind today is: how will the PWFA impact the culture of today's workplace and employers' compliance obligations? And how does that impact my business?
Thanks, Alicia. I'm Brett Anders, and today we're diving into the Pregnant Workers Fairness Act, or the PWFA, a landmark piece of legislation aimed at providing greater protections for pregnant workers. Joining me is Jennifer Bologna, a principal in our White Plains office. We are going to explore what the PWFA means for employers, how it compares to existing laws, and what steps businesses need to take to ensure compliance. Thank you for joining us today. Jennifer, let's start off with, can you give us a brief overview of the Pregnant Workers Fairness Act?
Sure. Thank you for having me today. The Pregnant Worker Fairness Act requires a covered employer to provide reasonable accommodations to an employee or applicant's known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, unless such accommodation would cause an undue hardship. I know that's a lot, and we'll break it down.
Right, so that sounds similar to what employers need to do anyway. How does the PWFA differ from other federal existing laws like the Pregnancy Discrimination Act or the ADA?
There are significant differences between those laws and the Pregnant Worker Fairness Act. The Pregnancy Discrimination Act prohibits discrimination against individuals who are pregnant, but it doesn't affirmatively require employers to accommodate pregnancy or pregnancy-related condition. And while the ADA requires employers to provide accommodations, pregnancy itself is not considered a disability. Thus, prior to the Pregnant Worker Fairness Act, pregnant workers could only obtain an accommodation under federal law if they had a pregnancy-related or some other kind of disability. Thus, the Pregnant Worker Fairness Act kind of closes the gap between the federal laws that required employers to reasonably accommodate those with disabilities and not discriminate against pregnant employees.
What are some of the key provisions of the PWFA that employers need to be aware of?
Well, at a high level, the Pregnant Worker Fairness Act prohibits employers from failing to make reasonable accommodations, from forcing employees to accept accommodations without engaging in an interactive process, from discriminating against employees based on their need for reasonable accommodations. You can't mandate leave for an employee, and this is an important one. One of the purposes behind the Pregnant Workers Fairness Act is to make sure that pregnant employees can continue to work. So you can't mandate leave when there's a reasonable accommodation, and you can't retaliate against an employee who requests or utilizes a reasonable accommodation.
What if one of those accommodations would require the employer to take away an essential job function? I know under the ADA, you do not have to accommodate somebody by removing an essential job function. Is that different under the PWFA?
Yes, that's different. And that's probably one of the most significant differences between the Pregnant Worker Fairness Act and the ADA. So remember when I was defining what the Pregnant Worker Fairness Act requires overall? One of the things that it states is that you need to provide accommodations to qualified employees. And to be qualified under the ADA, you need to be able to perform all your essential job functions with or without a reasonable accommodation. And that's one definition of qualified employee under the PWFA. But there's another definition. To be qualified, an employee who cannot perform all their essential job functions for a temporary period of time, but can do so in the near future, should still be reasonably accommodated as long as it doesn't create an undue hardship. So the short answer is yes, even if you can't perform all your essential job functions, you may still have to provide a reasonable accommodation to that employee.
And you just mentioned that you may have to do it for a temporary condition or for a temporary period. The question that always then gets asked is, well, how long do we have to do this for? Is there any guidance yet on for how long you may have to accommodate somebody by removing an essential job function?
So in the final regulations, there were some guidelines about what would constitute a temporary. And it's not really all that temporary. For a current pregnancy, someone who is currently pregnant, temporary may be 9 months or 40 weeks. But for individuals who need accommodations for other pregnancy or childbirth or related medical conditions, that period of time is not defined. And the EEOC in its final regulation said employers should look to other accommodation cases for guidance. So the only thing we know is that indefinite leave is not going to be deemed a reasonable accommodation, just like it's not a reasonable accommodation under the ADA. But beyond that, 6 months, 1 year may potentially be a temporary period of time.
Am I correct that under those situations where you're looking at a temporary period of time where you're moving essential job function, the employer is still able to consider whether or not doing so would be an undue hardship?
Yes, you can still consider undue hardship, just like you can under the ADA. And the factors more or less are the same. You can look at whether or not you can get the work done and the costs associated with it. But importantly, the Pregnant Worker Fairness Act anticipates that there may be some additional cost or there may be some period of time where essential job functions are being done by another employee or by a temporary employee, and or they're being put on hold for some period of time.
Are there other types of accommodations that the PWFA expects that employers will provide or you're seeing are being requested more often now under the PWFA?
Well, in terms of expects to provide, the final regulations talk about 4 predictable assessments that almost always have to be provided. The ability to carry or keep water nearby, the ability to take additional restroom breaks, take breaks to eat or drink, and to change your sitting or standing relationship per your job. So if you're normally sitting in your job and you need to stand, or you're normally standing in your job but need to sit, the EEOC would consider those kind of set accommodations. And we're seeing a lot of that. But it's not always so easy, depending on the industry, to just provide those. For example, in life sciences, you wouldn't necessarily want people bringing food into a secure laboratory, right? It potentially contaminate the work that's being done. So you still may need to engage in some interactive process there. Other accommodations that we see a whole lot of are requests for remote work, right? We're still seeing that. I'm tired. I'm getting near the end of my pregnancy. I need to be home.
I've seen that come up as well. And the question that I had was, sometimes the remote work is because the mother's recovering, they can't travel, or it's for lactation reasons. What if the request for remote work is because of a health condition with the child? Does that come under the PWFA, or is that something separate?
That's something separate. So again, in the final regulations, the EEOC made clear that the individual that's covered under the Pregnant Worker Fairness Act is the person who has limitations due to pregnancy, childbirth, or related medical conditions. It's not an affected family member. So in your example, it wouldn't be the child. So if a child was having difficulty with lactation or difficulty using a bottle, employee wouldn't be entitled to work remotely so that that employee could nurse the child, right? That would be a condition related to the child. Similarly, if a spouse was very nervous about a high-risk pregnancy, the spouse's nervousness would not be a condition covered under the Pregnant Worker Fairness Act.
Okay. Jennifer, one question that also comes up relates to documentation. So if a person is seeking an accommodation under the PWFA, are there any limitations, or is it different what you can ask them under the PWFA as compared to the ADA?
Yes, that's a very good question, and it's very important for employers to be aware of this. There's very limited medical information you can require under the Pregnant Worker Fairness Act. In fact, the whole purpose behind it is to streamline providing accommodations to pregnant workers or to those impacted by pregnancy and related conditions. So you can only get documentation if it's reasonable under the circumstances. And for those predictable assessments I was talking about before, in virtually all cases, you can't get any documentation at all. So you're not going to want to use the same ADA forms that you use when someone is seeking an accommodation for a disability.
And in terms of comparing it to the ADA, I know under the ADA, it has to be, disability. There has to be a major implication to a life activity. What about under the PWFA? Is the same level of severity of condition in order to obtain an accommodation, or is it something less?
It's much less. And this is another very important factor because the ADA was always out there. So if someone had a pregnancy-related condition that rose to the level of disability, they would have been entitled to an accommodation under the ADA. But under the Pregnant Worker Fairness Act, someone's entitled to an accommodation for something that's very modest or minor or even episodic. So if I'm tired and my doctor thinks that it would be better for the health of myself or my child to rest more frequently or work with my feet up, and therefore they're advising that I stay home, that would be sufficient. Just being tired.
Okay. Are there any specific obligations other than what we've discussed that the PWFA imposes on employers?
So the same posting requirement that you would have under Title VII, you'd have that obligation. And you'd also need to make sure you're engaging in that interactive process because if you do, showing a good faith effort, that may reduce liability if some liability in the future is found. The other thing that you need to make sure you're doing is training your frontline supervisors because to request an accommodation, all someone needs to do is just communicate the need for an adjustment or a change at work. And so the regulations in the preamble do talk about the need to train supervisors so they're not missing these requests.
Do you have any thoughts on how this new law is going to impact the workplace of the future and the culture of workplaces?
So in general, most employers are fairly supportive of pregnant employees. I'm not seeing a lot of pushback in providing accommodations to those when they're actually currently pregnant. In fact, one of the biggest policies requests that I have for even the smallest of employers is a parental leave policy because a workplace that shows it's supportive of parental issues is well sought after. However, I also have seen, a lot of issues arise in terms of removing essential job functions. While employers want to be supportive of pregnant employees, they have work to get done. And so if essential job functions are just being kind of taken off the table for what could be 9 months or longer, that's really hard for employers to handle. I've also seen a lot of changes that relate to lactation. There were laws on the books about lactation and a birthing parent's ability to pump at work. But the Pregnant Worker Fairness Act goes beyond the ability to pump or time off to pump. It actually provides the ability for a parent to nurse their child. It doesn't grant the right to proximity, so you can't just say, I want to be home so I could nurse. But potentially workplaces might change by children coming into the workplace to nurse, right? The law would allow someone to bring the child to you and nurse during work hours and your break time.
Is there any final advice that you would give to employers regarding the PWFA? Anything else that you want to share?
Sure. While many of the legal concepts will be similar to the ADA, there's going to be these important departures that are going to be important for employers to remember. There's going to be that emphasis on interactive process. There's going to be the importance of no delay, right? We've got to get these accommodations right up front. We've got to put them in place quickly. And simple accommodations need to be, granted potentially the same day they're asked for. You're going to have to remember those rules on medical documentation and how they're different from the ADA. And you're going to have to remember that temporary suspension of essential functions is going to be something that you're going to have to consider. And this is also a new law as we're discussing it, and there's currently legal challenges, including the scope of what constitutes pregnancy, childbirth, and related medical conditions. As it reads right now, it's incredibly broad. So employers are going to want to keep up for current updates and work closely with their legal counsel if there's any questions about whether or not a condition qualifies as something that needs an accommodation under the Pregnant Worker Fairness Act.
Thanks so much, Jennifer, and thank you for sharing your insights on the Pregnant Workers Fairness Act. This conversation has provided a lot of valuable information for employers navigating these new requirements. For our listeners, if you have any questions or need any further guidance, you can always feel free to reach out to us. Our information is on our website, jacksonlewis.com. Until next time, thank you very much.
Thank you for joining us on We Get Work. Please tune in to our next program where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.